All right, good afternoon, everyone. Court will resume with the July 19th, 2022 docket. And I'm waiting on there he is, Mr. Chapa.
Good afternoon, Judge.
Yes, sir, good afternoon, Mr. Chapa. I believe you're here on Armando Cardenas.
Yes, Judge, that's right.
And there's like three different cases. Let's go one by one here. See the number three, CR 22-02772D, Jose Armando Cardenas Jr. It'll be restitution hearing. State, any announcement on him?
Yes, Your Honor. The state will be requesting that restitution be set at $319.00. I believe the victim is present to testify.
Okay, and the victim is who now? The name?
Yesenia Gonzalez.
Okay, I don't see that name in the waiting room. What are the alleged damages here? What is it?
I believe it's a lawnmower, Your Honor.
A lawnmower? Only a lawnmower?
Yes, Your Honor.
Okay. Must be a Toro lawnmower because it's 319, you said?
Yes, Your Honor.
Okay. All right. And Mr. Chapa?
Judge,
Were you familiar with this case? Did you know about the lawnmower?
I'm familiar with the judge. If the state has evidence to put on, they can put it on. Otherwise, I have to object to any restitution being owed.
Okay. Let me hear from, who was it again? Samantha?
Yesenia.
I'm sorry, Yemen. Yesenia. I'm changing somebody's name here. Yesenia, not yet for Yesenia. Well, let me do another one here. CR 22-02773D, Jose Armando Cardenas Jr. What about that one, State?
Your Honor, a restitution letter was mailed out to the victim, Albert Sines. Mr. Sines has made no contact with their office. Therefore, Your Honor, the state would be requesting that restitution. If we can maybe move this hearing to allow Mr. Sines to get in contact with their office.
Well, no, well, first of all, Mr. Sines didn't show up here at court either, right? I don't see him in the waiting room or anything like that. You said he did not respond to your letter?
No, Your Honor, and a restitution letter was mailed out on July 13th, 2022.
Okay. We'll go ahead and make it zero restitution on that one. And then the last one I have here, I believe is CR 22-05963D, Jose Armando Cardenas Jr. What about that one, State?
Same announcement, Your Honor. A restitution letter was mailed out on July 13th, 2022 to Hilda Medina, Mia Tejerina, Miley Tejerina, and they have not made any contact with their office, Your Honor. So therefore, the state would be asking if we can have this hearing reset to a later date to allow those victims to get in contact with us.
Okay, now on this one, you said three different people got a letter?
Yes, Your Honor.
And nobody responded?
No, Your Honor.
Do you only send the letter or do you also do like a courtesy call or something? It will be email?
We just sent a letter giving them notice of a hearing. But as soon as the case is filed, we do also give them a call.
How about an email? No email to them?
If they provide us with one, we do send them an email.
Okay.
But in this case,
And once again, on Medina, Tijerina, no response, right?
No response. That's correct. That's correct.
Okay. I'm going to do a zero restitution on this one. And as well, if however they show up later that they want something, just tell them to go to JP court. Maybe they can get a small claim action.
Yes, Your Honor. And then as far as that first victim, she did make contact with me and we did provide her with the Zoom information 5 minutes ago. So let me.
Okay, we can probably wait a little while on that one. And let me go on to another case and see which one you want to do. Number one. CR 19-05-660D, Vianney Vianney Gonzalez Cuevas. I'm sorry, Vianney. I'm not French, so it's Vianney Gonzalez Cuevas. State, what's the announcement of this one?
Your Honor, yes, our office did make contact with the victim, Victoria Reimer. Ms. Reimer stated that she did not seek any medical treatment due to this assault. So therefore, Your Honor, the state will be requesting a restitution be set at 0.
It'll
No
be
objection, Your
zero,
Honor.
zero restitution, and Mr. Paco Gonzalez is here representing VNA. So it'll be restitution 0. Okay, Mr. Gonzalez?
Okay, Judge, can I be excused?
You're excused. Have a good day, sir.
Have a good day, Judge. It's good to see
You
you.
too. Bye-bye. Mhm. What do you want to call next?
PD,
PD. Is PD on, Mr.
Number
Ted
6.
Lopez?
yes, number 6.
Number 6. Ted Lopez. Number 6. All right. Mr. Lopez, one of your cases here, I don't know if it's just more, but this is one of them. CR 2204 280D, Juan Miguel Peña. This is a compliance hearing, right?
That's correct, Judge.
I think defendant was to provide proof of installation.
You already did.
He already did.
Yes, Judge, he did. It's been reset already to 12/7/22 at 9 a.m.
Very well. That's taken care of.
Restitution number 12.
So this case, CR 2204 280D, Juan Miguel Peña, reset date 12/7/22, 9 a.m. All right, very well. Did you have another one, Mr. Lopez?
I did, Judge. It was, I believe, Jonathan Lee Guerra. It's a restitution hearing.
Correct. Correct. CR 2205 961D, Jonathan Lee Guerra. Also restitution. State, any announcement on this one? You're muted, Mr. Guerra.
Sorry about that, Your Honor.
Okay.
Yes, a restitution letter was made out to Luiana Barreras. Ms. Barreras has not made contact with her office, Your Honor. Therefore, the state would be requesting that restitution be set at 0.
All right, Mr. Lopez, 0 restitution, sir. Okay.
Thank you, Judge.
Thank you. Is that it for you, sir?
That's all I have, Your Honor. May I be excused?
You're excused. Have a good day. Thank
I
you.
don't know, this might be the victim.
That could be a thing. It's got a Y, no?
Mhm.
Let's see here. Some YC is connecting. Let me find out. Where is YC? Oh, there he is. Okay. Yes, ma'am. What is your name?
Man with the mask, black mask, what is your name?
Can you hear me? Is your name Yesenia? No, did you hear me?
Hello.
Yes, ma'am. Can you hear me?
Yes,
Yes. What is your name?
Yara Corbett.
Okay, no, that's not-
No.
That's Roby's case.
Okay. All right. We'll call you like a little while, man.
There's no Yesenia.
No, Yesenia has not checked in their state.
Your Honor, let me give her a phone call right now.
Okay.
I'm gonna bring in Roby.
We're gonna bring in another set of lawyers, okay,
2 minutes.
for a civil case. All right, let me see here. Court will continue with the July 19th, 2022 docket. And we have here F6902-18-4 in the matter of the marriage of Corbett and Corbett. All right, good afternoon, Mr. Davis, and good afternoon, Mr. Flores.
Good afternoon, Judge Tim Davis from Mr. Corbett.
Yes, sir. Need to unmute Mr. Flores.
Judge, I haven't left this position since 9 this morning. Roby Flores.
You're still doing depots?
No, I was in a hearing, but literally just finished that about 15
Oh,
minutes ago. So
okay, very good, very good. We're here on this one, Corbett versus Corbett. What do we have here, Mr. Davis?
Judge, I have a few motions that were set, and I know Mr. Flores, they had filed a motion for continuance on Friday and then another amended one this morning, and I understand that. But I just sort of want to see if we're going to reset the case, could we do it here within the next couple of weeks? because there's, some of these things I think need to be heard sooner rather than later.
Sooner rather than later. You got it for 2 weeks?
Judge,
Let's, okay, file an order for setting hearing date and, yeah, we're gonna try to swing it in there in a couple of
Yeah.
weeks.
Judge,
Yes, sir, Mr. Flores. Yes, sir.
let me apprise the court, we're set for a final in this hearing in September.
In
Except for
September
Trial.
or
Yeah,
for
we're set-
trial?
We're set for a final hearing in September. Yes, sir.
I have a question. Is it for jury trial or bench trial?
Jury.
Jury? Oh, man, I don't know that we can swing the jury trial. Let me see what else.
We're set for it is my point. And
Okay.
and it's
Well-
set, and some of these motions, if it's a jury issue, they're not entitled to certain relief that they're requesting.
Okay.
Well, I don't know that any jury issues are contained in my motions, but I'm trying to get, after all these years, a formal temporary orders in place.
We have, we have agreements and temporary orders in place.
Uh-huh.
And
No.
they're either in forms of Rule 11s. I mean, if you want to put it in a formal order, I'll sign off on it. We don't have to.
But that's where we get into, that's why we need to have a hearing, because there's some issues, because there's some Rule 11 agreements, there's some orders that were just submitted and signed. We've had evidence where my clients presents us on the child support as to what he makes and what the child support should be under the guidelines. That got set aside because of non-appearance. And then, so I just want to try to get all this straightened out. And I understand we may have an issue in September if we're going to have to proceed with the jury trial on that issue as to whether or not we'll be able to go forward. There's also issues, Judge. These people own 4 properties, 4 houses, 7 vehicles. My client has access to nothing. He's got 4 kids, and he's having to drive around in a Jeep for the past 3 years because he can't get access to one of the vehicles where all his children could fit in. There's $144,000 that are on deposit at the courts registry for a property they sold. There was a foreclosure back in December that I had to file a restraining order in Cameron County and then go into federal court in Brownsville to stop that. So they were able to sell that property and get those profits. So there's just a lot of stuff, but we don't have any formal orders on that.
Well, let me back up just a little bit. First of all, there is money in the registry of the court, but there's also an order from the AG that says he owes over $70,000. So we don't think he's going to be getting any money from that that's in the registry of the court. We have orders pertaining to the child support. They did have a motion that got set aside, but reinstated the previous agreement and or order. I would like for Mr. Davis and I to talk to the AG and get that issue resolved, because they're saying they're paying money to the AG and the AG is saying they're not holding any of the money. At the end of the day, there is a FINA that says he owes over $70,000. Now,
right, because the problem is, Judge, I mean, I'm sorry, Roby, go ahead.
If there's money that he should be credited, I'm all in favor of giving him credit for the money that he has in fact paid. But if it hasn't been paid, then that's money that's coming to her. And we don't have any problem letting it sit there, because the property issues are going to be dispositive of all the assets that the parties may or may not have. There are some separate property claims. Those aren't going to be resolved in the temporary order. That's for a final hearing. Custody isn't going to be resolved in a temporary order. That's for a final hearing. There is a visitation order set out. There's agreements with support set out. And like I said, if Mr. Davis is not wanting to operate, there hasn't been any problems with Mr. Corbett getting his visits. And you know that because there's been no motions to enforce saying he has.
There's no order to enforce, Judge. That's the problem. And it's the same thing with the child support. I mean, there's a 1 paragraph order It doesn't say, when child support, it doesn't have all the language that's required under the family code. I've talked to the Attorney General about it as well. Meanwhile, he's been making payments every month to her, and he went through the Attorney General. She refuses to come in and sign the affidavit of the informal payments, but he doesn't have any option and for the past year or so, the child support's been withdrawn from his paycheck every time he gets paid. So it's accumulating there. It hasn't been distributed because the Attorney General said they were holding it because they don't have a valid order in place. So I'm just trying to get an order in place, and it's going to result in Mr. Flores' client getting that money.
Like I said, if there's a question with the drafting, this is the first I've heard of that. There's a problem with the drafting of the order. We can redraft the order. I'll sign off on it that says what he's supposed to be paying based on the agreements. And whatever payments he's made in there, if they're in there because they're saying they're not, then he's going to get credit for it. Now, if you're telling me something different, that there's direct payments, that's a different issue.
There were direct payments for a while, and then the income holding order went in.
I've not received any of those things in writing. That there's an issue of direct payments that they want credit for. I suggest that Mr. Davis and I draft an order that says when it was supposed to start, and according to our agreements, if they're saying, I've never heard the AG say we have an invalid order, but if they're saying that, we can draft a valid order.
All you have to do is look at the order. You can tell it doesn't comply with the family.
No, I can't tell anything because the AG is not the Court of Appeals. They don't, and the AG doesn't decide what's valid or invalid. But there's an order that specifies how much he was supposed to pay and how it was supposed to be paid. If there's a problem with that terminology, I will work with you on a valid order. I will work with you if there are direct payments. Show me those direct payments. I mean, there's either a check showing he paid her or there isn't. And it's like being pregnant. You either are or you aren't.
Right.
And you're not gonna get any argument from me if there's direct payments. I don't think you're gonna get any arguments from Ms. Corbett.
Good. This is why we need to have a hearing on these issues.
Well,
He can testify to all the payments he's made, all the money.
The testimony is not going to be his testimony that proves that he paid it. It's the paper.
Right.
So show me the paper and we'll give you credit. It's no big deal. I don't need to waste court's time of 4 hours going through documents that you and I can do.
At the end of the day, though, Judge, this is a divorce with 4 minor children. And they have been on their own doing sort of standard visitation, but there is no order in place about that. It just says that he was entitled to 1st, 3rd, and 5th, Friday at 6 to Sunday at 6. They've been doing all the holidays.
Give me the order, give me the holidays, I'll sign it, Tim. Give me Friday. Send me an order, Friday through Sunday with the holidays, and I'll sign it.
No, he wants extended. I mean, he's entitled to extended.
That's a different issue. But you're saying there's
entitled to it.
You're saying there's
okay. Did you guys ever mediate this case with somebody?
3 times, Judge. And we go the whole time and you reach agreements, and then they blow it up at the end every time.
That's not true. First of all, the blow up has been on Mr. Corbett's outlandishness of a value of a corporation. And we've gone over this with the court with an expert report showing a certain value, and they have no expert. And we've given them an expert report from San Antonio, the King Group, very well-known group out of San Antonio. And at the end of the day, they don't want to accept that, but yet they don't want to tell us except give us a number with 7 figures with no basis other than this is what I want. Well, yeah, that's never going to get so. You're right. That's why we needed the final hearing for that. But a temporary order hearing is not going to resolve that.
So, so under that issue, you have an expert already for trial.
Yes, sir.
Which is,
No, that's Judge. That expert is not qualified to testify. And I've hired consulting CPAs, and they said this would be if somebody presented. It's not even signed, and it couldn't be presented. I mean, you'd lose your CPA license if somebody tried to sponsor that.
Okay. Anyway, we're set for jury trial in September.
Yes, sir.
September 26th, 9 a.m.
September 26th.
Yeah. And so I want to allow you guys to try to settle the matters or clean up what you need to clean up with any orders. And
Well, can you give us a date then, where I can, for entry of the temporary orders, and hopefully between now and then, me and Mr. Flores can agree on them?
if as soon as you guys agree on them and sign them, just submit it. That'll do it. So I don't have
No,
to
but
wait a
if there's
couple of
no
weeks.
date, then it's just gonna get ignored. That's what happens with everything in this case.
Well, this case is 1,313 days old. So when you tell me I want something in 2 weeks, I'm like, really? I mean,
Well,
2 weeks
but-
versus 13.
Yeah, and it's about the
You
fourth
know?
time I filed a motion to hinder temporary orders
It's
too.
like, you're telling me you're not in a hurry. You're telling me everybody's taking their time. You're telling me somebody's ignoring mediation. Somebody's not doing their good faith part here when it's 1,300 days old.
We've
I
gone
don't
to
know.
mediation 3 times.
Well, file what you need to file. I'll see if I'll look at it or not. And but we know we have a date for September 26th, 9 a.m. Yeah, file
Yes,
what
sir.
you want to need to file, and I'll see what I can do there.
Alrighty, Judge, thank you.
Send me the proposed orders, Tim.
Try to work it
will.
out. Try to clean it up. I don't know that. I mean, oh, okay. Anyway, your excuse. Have a good day, guys.
Thank you, Judge.
Okay. Court will resume with the July 19th, 2022 docket. And let me see here. We're going back to CR 22-02772D on the case of Jose Armando Jr. That's a restitution hearing. And I believe Yesenia Gonzalez is already on board and ready for to put on some testimony, Mr. Guerra?
Yes, Your Honor.
All right, Ms. Gonzalez, you swear that, can you hear me, Ms. Gonzalez?
Yes,
You swear the testimony you're about to
Raise your right
give
hand.
would be the truth, the whole truth, and nothing but the truth?
yes.
All right, you can put your hand down and Mr. State, get it going.
Hi, good morning. Can you please state your full name for the record?
Yesenia Gonzalez?
And Ms. Gonzalez, were you a victim of a theft case that occurred on February 28th, 2022?
Yes.
And what property was taken from you?
A lawnmower?
And were you able to recover that lawnmower?
Not that one. I had to purchase a new one.
And the lawnmower that the new lawnmower that you purchased, was it the same make and model as the one that was stolen from you?
Yes.
And how much did that new lawnmower cost you?
$319.
Is that $319?
Yes.
Thank you. No further questions, Your Honor. We pass the witness.
All right, Mr. Chapa?
Hi, Ms. Gonzalez, can you hear me okay?
Yes.
Just very briefly, the lawnmower that was stolen on February 28th, who purchased that lawnmower?
I purchased it.
With funds that belong to you?
Yes.
Did you pay for cash? Did you pay with the card?
That one I have paid cash.
Okay. How old was that lawnmower?
I want to say about a year and a half old.
generally speaking, ma'am, are used items cheaper than brand new items?
Yes,
So would you agree with me that your used lawnmower would maybe cost less than $319?
it would, but I wouldn't have to have purchased a new one if I would still have my old one.
Thank you. I have nothing further, Judge.
Anything else, Mr. Guerra?
Nothing further, Your Honor. The state would just request that restitution be set at $319.00 to Miss Yesenia Gonzalez.
All right. Okay, then in CR 2202-772D, in the case of Jose Armando Cardenas Jr., court will hereby order the $319 as restitution payable to Yesenia Gonzalez. Thank you, ma'am. Your excuse. Have a good day.
Thank you.
Thank you.
Ms. Gonzalez.
All right, now, Mr. Guerra, do we have another case? Yes, sir. We have another one here. Thank you, Mr. Chapa. You make excuse. Have a good day.
Thank you, Judge. Enjoy the week.
Yes, sir. Is it over here? Okay. Number 2. Okay, the next case I have is CR 21 09. I'm sorry, CR 21 09852D Cementa Cavazos. Non-compliance hearing, I understand. Was she on PTD or what?
Yes,
Yes.
Judge, Jessica Ramirez on behalf of probation. She was placed on PTD on April the 4th for a possession of marijuana. It's a regular 2-year PTD program, and she was arrested on April 11th out of Cameron County for a DWI judge, April 10th for a DWI judge at South Padre Island.
April 10, Padre Island. Was it the DWI, right?
Yes, Judge.
Okay. Yes, sir, Mr. Garcia.
Good afternoon, Your Honor. Carlos Garcia on behalf of Samantha Cavazos.
Yes, sir. Good afternoon. Oh, so state, what are you requesting in this case?
Your Honor, state would request that the defendant be removed from pretrial diversion program, and we move forward with sentencing the defendant, Your Honor.
Okay. I have a question on the DWI case. I know that it was April 10th, and I'm pretty sure there's probably no disposition yet. Anything going on in that case? Any pleas or any jury trial settings?
Your Honor, respectfully, Carlos Garcia on behalf of Samantha Cavazos, we're respectfully asking the court to continue this determination. We do believe that there's going to be an ultimate resolution where she'll be exonerated in this matter. And so we respectfully ask the court to forego sentencing her or moving forward or taking her off the PTD program at this time.
Okay. Okay. That's why I asked, is it still pending or what? And apparently it is. Court will be willing to give a little bit more time to see what the resolution is, and then we'll go from there.
Thank you, Your Honor.
I mean, it's not like she got arrested for, again, POM, and that's an automatic, so to speak. DWI, there might have been a non-probable cause arrest or stop. You know what I'm saying? So,
Yes.
so we'll give her some time. We'll
Thank
give
you,
her
Judge.
the benefit of the doubt.
Thank you, Your Honor.
Let's set it for status hearing. Let me get a date right now. Let me see if I get it. Only because of that. Had it been an automatic POM, I can see the difference. And one of those things where she didn't learn her lesson and so forth. But all right, it's a DWI. It's a little bit different. Let me get a date here from my court coordinator. It'll be status on the 9 compliance.
Yes, Your Honor.
November 9th? The time? At 9?
It's a 90-day reset to see if there's.
November 9 at 9? November 9 at 9. Okay, guys?
Thank you, Your Honor.
We'll reset it. You all may be excused. Have a good day. Thank you. State, that'll do it, right? For right now?
Your Honor, there's actually one more restitution hearing.
Sure. Give me the name.
CR 22-05665D. Fabricio Perez Garcia.
Yes, sir. CR 22-05665D. Fabricio Perez Garcia. Restitution. And for the record, Garcia is not in the waiting room, nor is the attorney. But State, do you have an announcement?
Yes, Your Honor. I did reach out to the defense attorney, Mr. Richard Gonzalez, and we did agree to an amount.
Okay.
And that agreed amount was $2,990.01.
To who?
Made payable to Rigoberto Garcia. Rigoberto Garcia.
Rigoberto?
Garcia, yes.
Rigoberto Garcia. Was that 2990.01?
2990.01. Yes.
That's what I have.
And we also have number 11.
Okay, I'm gonna put here agreed to. And I think there's one more. Juan Daniel, number 11, CR 22-05-928D. Juan Daniel Montalvo Mendoza, restitution hearing, state.
Yes, Your Honor. A restitution letter was mailed out to Livia Montalvo on July 13th, 2022. Ms. Montalvo has made no contact with her office, Your Honor. The state would be requesting that restitution be set at 0.
It'll be 0 restitution. And for the record, defendant Mendoza or attorney Youngs are not in the waiting room. So what is that it right now?